जिन्हें सीट्स नहीं मिल पाई हैं उनके लिए मैं रिक्वेस्ट करना चाहूँगा, इसी फ्लोर पर हमारा प्लेनरी हॉल है, वहाँ एलईडी स्क्रीन्स लगी हुई हैं एंड यू विल बी एबल टू सी लाइव all the proceedings of this event, this inaugural session. So I will request all of you to please go there and take your seats there and see and be part of the proceedings of this inaugural session of today's National Conference on Mediation. The plenary hall is on the same floor, 5th floor, and you can go and take your seats there. जिन्हें सीट्स नहीं मिल पाई हैं उनसे मैं रिक्वेस्ट करूंगा, ऑन द सेम फ्लोर वी हैव अ प्लेनरी सेशन एंड वी हैव एलईडी स्क्रीन्स ऑल्सो देयर, तो आप वहाँ पूरी प्रोसीडिंग्स को देख सकते हैं, यू कैन बी पार्ट ऑफ दिस प्रोसीडिंग्स। तो आप वहाँ जाकर अपनी जगह ले लें, आपसे रिक्वेस्ट है आप प्लीज़ वहाँ जाएं प्लेनरी हॉल में और वहाँ जाकर अपनी जगह ले सकते हैं।
अनाउंस तो आपको करना है।
नहीं आप मुझे
नहीं सर, मैं लिस्ट आपको इसलिए नहीं दे रहा हूँ अभी क्योंकि ये भी कंफर्म
बाकी का जो है वो बता
तो ये भी जो है 31 हम देख तो
अभी कौन आया था जस्टिस
नहीं, ये कोई है नहीं, ये तो कैसे गया
रेडी टू कम, आप अनाउंसमेंट कर दीजिए। ऑल दीज पीपल विल कम फ्रॉम बीच में ओनली, तो आप अनाउंसमेंट शुरू कर दीजिए। अच्छा, ऑन द स्टेज। अच्छा हाँ,
आप सभी से करबद्ध प्रार्थना है, रिक्वेस्ट है, आप प्लीज़ सभी बैठ जाएं, अपनी अपनी सीट्स ले लें। ऑनरेबल चीफ जस्टिस ऑफ इंडिया इज जस्ट अबाउट टू रीच इन द हॉल ऑन द स्टेज। आप सभी से रिक्वेस्ट है कि आप प्लीज़ अपनी अपनी जगह पर विराजें।
are coming.
दिव्य सज्जनों, ऑनरेबल चीफ जस्टिस ऑफ इंडिया, आइए हम सब अपने अपने स्थान पर खड़े होकर करतल ध्वनि से हार्दिक स्वागत करें, अभिनंदन करें ऑनरेबल चीफ जस्टिस ऑफ इंडिया डॉक्टर जस्टिस DY चंद्रचूड़ का और सभी डिग्निटरीज का। और आप सभी अपने स्थान पर ही खड़े रहेंगे क्योंकि राष्ट्रगान होगा, इसलिए आइए हम सब अपने अपने स्थान पर खड़े होकर राष्ट्रगान में शामिल हों।
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे, तव शुभ आशीष मांगे। गाहे तव जय गाथा, जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
थैंक यू वेरी मच लेडीज एंड जेंटलमैन। देवियों सज्जनों, यह हम सबके लिए बहुत सौभाग्य की बात है कि नालसा और MCPC की छत्र छाया में समाधान द्वारा आयोजित इस 2 दिवसीय नेशनल कॉन्फ्रेंस के इनॉग्रल सेशन में ऑनरेबल चीफ जस्टिस ऑफ इंडिया डॉक्टर जस्टिस DY चंद्रचूड़ का शुभागमन हम सबके बीच हुआ है। आइए एक बार करतल ध्वनि के साथ उनका अभिनंदन करें, उनका स्वागत करें ऑनरेबल चीफ जस्टिस ऑफ इंडिया का। इस अवसर पर मंच पर गरिमामयी उपस्थिति है ऑनरेबल जज सुप्रीम कोर्ट ऑफ इंडिया मिस्टर जस्टिस संजय किशन कौल का, जो नालसा के एग्जीक्यूटिव चेयरमैन और MCPC के चेयरमैन भी हैं। प्लीज वेलकम ऑनरेबल मिस्टर जस्टिस संजय किशन कौल। We are privileged to have with us the Honorable Attorney General of India, Shri R. Venkatramani, Honorable Chief Justice of Delhi High Court and Patron-in-Chief Samadhan, Honorable Justice Satish Chandra Sharma ji, Honorable Judge, Delhi High Court and Chairman, Overseeing Committee Samadhan, Honorable Mr. Justice Manmohan, Honorable Judge, Delhi High Court and Member, Overseeing Committee Samadhan, Mr. Justice Sanjeev Sachdeva ji, and Senior Advocate, President, Delhi High Court Bar Association, Mohit Mathur ji। आप सभी का आज के इस आयोजन में बहुत बहुत स्वागत है, अभिनंदन है, वंदन है आप सबकी गरिमामय उपस्थिति के लिए। देवी सज्जनों, मेडिएशन या मध्यस्थता हमारे जुडिशियल सिस्टम में अल्टरनेटिव डिस्प्यूट रेजोल्यूशन के यानी ADR की एक बहुत महत्वपूर्ण कड़ी है। बीते वर्षों में लगातार जो प्रयास हुए हैं, जो एफर्ट्स किए गए हैं, उसकी वजह से मेडिएशन प्रोसेस आज उस मोड़ पर है जहां हम उसमें बहुत सारी संभावनाएं देख सकते हैं, देख रहे हैं और उसको लेकर बहुत सारी आशाएं हमारे मन में हैं। 2 दिन के इस नेशनल कॉन्फ्रेंस मेडिएशन एट द डॉन ऑफ ए गोल्डन एज, इसमें आज के समय में इसमें जो पोटेंशियल है उसको जानने का, उसको समझने का, और चूंकि वो हजारों वर्षों से हमारे जीवन शैली का हिस्सा रहा है, तो हमारे वो रगों में है, संस्कारों में है, तो उसका आम लोगों के हित में किस तरह से प्रयोग हो सके, उस पर तमाम चर्चाएं होनी है। मेडिएशन वो सिस्टम है जहां व्यक्ति की गरिमा, परिवार की मान मर्यादा, समाज, संस्था या संगठन के हित सबकी रक्षा होती है। यहाँ सब जीतते हैं, हारता कोई भी नहीं है, चाहे वो कोई भी पार्टी हो या मीडिएटर हो या पूरा सिस्टम है, सबकी जीत है। मेडिएशन के माध्यम से लोगों के परिवारों के जीवन में सुख हो, शांति हो, प्रेम हो, इसी कामना के साथ आइए मैं निवेदन करूं ऑनरेबल चीफ जस्टिस ऑफ इंडिया और ऑनरेबल जो डिग्निटरीज हैं डायस पर कि वो अपने कर कमलों से दीप प्रज्वलन के लिए पधारें और दीप प्रज्वलन के साथ सबके जीवन में हम न्याय के और न्याय के माध्यम से सुख और शांति की कामना करें. I will request Honorable Chief Justice of India and all the dignitaries on the dais to come for the lighting of lamp. बहुत बहुत आभार ऑनरेबल चीफ जस्टिस ऑफ इंडिया और सभी डिग्निटरीज का उनके इस कृपा के लिए, उनके स्नेह के लिए. देवर सज्जनों, आइए इस अवसर पर जो इनॉग्रल सेशन है 2 दिन के नेशनल कॉन्फ्रेंस का, उसके औपचारिक जो पक्ष हैं उसके साथ आपको जोड़ूं. उससे पहले यहाँ इस मंच पर स्वागत करने के लिए मैं निवेदन करूँगा जस्टिस संजीव सचदेवा, जज दिल्ली हाई कोर्ट एंड मेंबर ऑर्गेनाइजिंग कमेटी समाधान. ऑनरेबल चीफ जस्टिस ऑफ इंडिया डॉक्टर जस्टिस DY चंद्रचूड़ को यहाँ पर एक प्लांट भेंट करके उनका अभिनंदन, उनका स्वागत इस अवसर पर हम सब की तरफ से और उन सब की तरफ से जिनके जीवन में आपके सोच और आपके विजन के माध्यम से न्याय की, शांति के, सुख की जो खुशहाली आती है, ऐसे चीफ जस्टिस ऑफ इंडिया, लेडीज एंड जेंटलमैन, प्लीज पुट योर हैंड्स टुगेदर टू वेलकम ऑनरेबल चीफ जस्टिस ऑफ इंडिया. I will request Justice Yashwant Verma, Judge Delhi High Court and Member Overseeing Committee Samadhan, to welcome Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India, and Executive Chairman NALSA and Chairman MCPC. Justice Yashwant Verma to welcome Honorable Mr. Justice Sanjay Kishan Kaul. I will request Justice Naveen Chawla, Judge Delhi High Court and Member Overseeing Committee Samadhan, to welcome Shri R. Venkatramani, Attorney General of India. Justice Naveen Chawla, please. आप सबके करतल ध्वनि के साथ देवी और सज्जनों, बहुत बहुत स्वागत, अभिनंदन है उन सभी विभूतियों का. और हमारे इस ऑडिटोरियम में, सभागार में ऑनरेबल जजेस ऑफ सुप्रीम कोर्ट अपनी प्रेजेंस से हम सबको अपनी ब्लेसिंग्स देने के लिए पधारे हैं. उनका भी हम स्वागत अभिनंदन करना चाहते हैं. एंड आई विल रिक्वेस्ट जस्टिस पुरुषेंद्र कुमार कौरव टू वेलकम ऑनरेबल जस्टिस P. नरसिम्हा. उनको यहाँ पर प्लांट भेंट करके उनका हार्दिक स्वागत अभिनंदन करने के लिए मैं रिक्वेस्ट करूँगा. जस्टिस पुरुषेंद्र कुमार कौरव, वो इज मेंबर ऑफ ओवरसीइंग कमेटी समाधान. Honorable Mr. Justice P. Narasimha, Honorable Judge, Supreme Court of India. Ladies and gentlemen, put your hands together to welcome Honorable Judge, Supreme Court of India. I will request Justice Sudhir Kumar Jain to welcome Honorable Mr. Justice Asaruddin Amanullah Sahab, who is gracing the occasion and he is here to bless us. Please put your hands together to welcome Honorable Mr. Justice Ahsanuddin Amanullah Sahab. I will request Justice Vikas Mahajan to welcome Mr. Justice Rajesh Bindalji, who is gracing the occasion and sitting with us. आपकी तालियों के साथ उनका भी बहुत बहुत स्वागत, अभिनंदन है आज के इस अवसर पर यहाँ उनके गरिमामय उपस्थिति के लिए. और आप सभी का हार्दिक स्वागत, अभिनंदन. मैं निवेदन करूंगा सीनियर एडवोकेट और दिल्ली हाई कोर्ट बार एसोसिएशन के प्रेसिडेंट श्री मोहित माथुर जी से कि वे फॉर्मली औपचारिक रूप से आप सबका स्वागत करने के लिए पधारें।
Honorable the Chief Justice of India, Justice Dhananjay Chandrachud ji, Honorable Justice Sanjay Kishan Kaul ji, Judge Supreme Court of India, Executive Chairman, National Legal Services Authorities, and Chairman, Mediation and Conciliation Project Committee of Supreme Court, other honorable judges of the Supreme Court of India, the learned Attorney General, Shri R. Venkatramani ji, Honorable the Chief Justice of our own High Court, Shri Satish Chandra Sharma ji, Honorable Justice Sanghi, Chief Justice Uttarakhand High Court, Honorable Justice Manmohan ji, Judge Delhi High Court, and Chairman of the Overseeing Committee of Samadhan, all the other honorable judges of the Delhi High Court, as well as the honorable Chief Justices and judges from other high courts who are present today and gracing the occasion, former judges and former Chief Justices of the High Court of Delhi as well as other courts, honorable members of the Overseeing Committee of Samadhan, honorable members of NALSA and MCPC who have joined us today, Mr. Jatan Singh and Sandeep Sharma, Vice President, Honorary Secretary of the Delhi High Court Bar Association, Mr. Chetan Sharma ji, Additional Solicitor General of India, other office bearers of the Executive Committee of Delhi High Court Bar Association, former presidents and office bearers of the Delhi High Court Bar Association, respected senior advocates and distinguished colleagues at the bar, and my most cherished members of the Delhi High Court Bar Association, ladies and gentlemen, a very good evening to all of you. Let me, at the very outset, thank Honorable Chief Justice of India and Justice Kaul, the honorable judges of the Supreme Court as well as our High Court, and all dignitaries who have graced this occasion with their presence. Sir, thank you for taking the time to be with us. We are always excited to have you amidst our High Court family. I'm sure you can tell that same by the turnout today. And of course, we extend our heartfelt gratitude for your constant encouragement and guidance in our pursuit to excel as an institution. It is indeed my proud privilege to welcome all of you here today to this National Conference on Mediation at the dawn of a golden age, organized by our Samadhan in collaboration with NALSA and MCPC of the Honorable Supreme Court of India. As we assemble here today to acknowledge and celebrate the dawn of a golden age of mediation, it was but obvious that this is the result of our legal framework today, acknowledging and lauding the immense impact mediation has had in the lives of litigants, lawyers, as well as the judges, and how it has proved to be a boon for the burdened judiciary as well as the litigants awaiting justice. I'm sure we have all heard the stereotypes about our profession here in the subcontinent, and over the years, our ears have gotten tired of the same old stories and statistics about the pendency in our courts and the times that it takes for final disposal of cases. The advent of mediation presented us with a fantastic solution in this regard, and today we can safely say that a new arena has emerged to take care of our such woes. Of course, we look forward to hearing your insights on this, sir, and I would request the other dignitaries on the dais, as well as the speakers scheduled to speak tomorrow, to share their experiences and ideas. I have always honed a keen interest and an avid reader of history and the Indian mythology, and I've always felt our lives have always been filled with mediators, and the concept of mediation has been embedded in our mythology as well as reality since the days of yore. In the Ramayana, Lord Hanuman and Prince Angad assumed the role of mediators to prevent conflict. In the Mahabharata, Lord Krishna tried to mediate amongst the Kauravas and the Pandavas, but tragically we know now that both these attempts failed. What we take away from this is that despite resolution depends, that dispute resolution depends on the will of the parties involved. At the end of the day, and the failure of such amicable resolution may prejudice each party in one way or the other. On the other hand, a mediator must ensure actual tangible justice while balancing the needs of opposing parties. Looking at it that way, it is indeed a delicate job, or rather, an art. I personally know some counsels and judges as well who are tremendous mediators, and finding middle ground comes naturally to them. Some of our trained mediators are so adept at the process that they are able to resolve not only the issues referred to them, but also ancillary and related differences amongst parties, thereby enlarging the scope of mediation. Through the course of human history, we find fascinating instances of mediation. When you read of Nelson Mandela, Mahatma Gandhi, or Henry Kissinger, you learn that mediation and negotiation require strategic planning, perseverance, and immense patience. But then, these people and their ability to sit with their adversaries change the course of history. When you are pursuing an adversarial litigation, naturally there is an element of enmity, seeing the opposition as a threat or a barrier. What mediation does is allow the mind to remove that adversarial aspect and think more on the lines of problem solving or achieving a peaceful coexistence. To be honest, when I delved into criminal law, I had not imagined the rate at which criminal cases would come to be disposed of today with the help of mediation. I dare say, once our clients realize their actual problems and let go of their emotions and ego, it does not take long for them to realize that paying our fees isn't in their best interests. At the end of the day, mediation simply works because in a society, we are all meant to coexist. And maybe it has dawned on all of us that we simply do not have the time to be shackled by paperwork and court dates. In some cases, it goes on for generations. From 2006, the setting up of our Delhi High Court Mediation and Conciliation Center, that is Samadhan, showed us the true potential of mediation. At this juncture, ladies and gentlemen, I must take a moment to tell you about the foundation of Samadhan and its growth over the years. The foundation and smooth functioning of Samadhan is a testament to the perfect synergy between the bench and the bar here at the Delhi High Court, something that we are all quite proud of. Samadhan, as the name suggests, helps resolve not just cases before it, but many times resolves relations and strained associations. Today, it can be said that the name Samadhan is synonymous with speedy resolution and justice. There was an initial hesitation against mediation from the bar, but this institution grew amid apprehensions about mediation being antithetical to litigating lawyers' mindset, and the freers were allayed. We, as an institution, have come to realize that mediation had emerged as a reliable mechanism for the speedy disposal of cases. The functioning of Samadhan was entrusted to the bar, and a committee of judges and members of the bar jointly oversee the smooth running of the facility, and a reliable system of checks and balances has thus been achieved. While Samadhan is responsible for training and maintaining an immensely talented pool of over 250 mediators who are members of the Delhi High Court Bar Association. They also conduct training sessions for mediators all over India. A testament to the power and efficiency of Samadhan is the fact that today we start our collaboration with the Uttarakhand High Court as well. We take pride that some of our mediators have over the years become the go-to choice, and cases are referred to Samadhan from all over the Honorable Supreme Court, our Delhi High Court, and the subordinate courts as well, including pre-litigation mediations, might I add. Samadhan today functions out of a 10,000 square feet facility space, providing state-of-art facilities to conduct in-person or virtual mediation sessions. And for the benefit of the parties, there is an annexed space for children to spend their time while their parents engage in their respective sessions. Once the session kicks off, we generally have around 24 mediations going on simultaneously. Video conferencing, an irreplaceable facility in these times, sir, was provided in Samadhan in 2017 itself for the benefit of outstation or infirm parties to mediation who could not remain physically present. Samadhan has over the years achieved great heights, and has been an irreplaceable catalyst in thrusting us toward what indeed appears to be the golden age of mediation. The constant support from all my lords here at the High Court has emerged as a true certificate to the collaboration between the bench and the bar at Samadhan. As a representative of the bar and as a representative of the overseeing committee of Samadhan, I feel we need to let this movement and institution grow in the world of dispute resolution in order for mediation at the Delhi High Court to be a rewarding and enriching pursuit for the professionals involved, hardworking and dedicated counsels who devote immense effort and work for the people of Delhi and the seekers of justice. As the time passes, we realize we have to embrace change. If lawyers were afraid back in the day of just mediation, let me remind you all that they are creating artificial intelligence that gives real-time legal advice for any given set of facts and extant law. So we might just be dinosaurs before the next great metaphorical asteroid. Jokes apart, if there is something, a metamorphosis that helps and aids the society, there should not be any resistance to it. I can say on behalf of the members of the Delhi High Court Bar Association that we look forward to seeing the growth of mediation. I am certain in the times to come, mediation may become the main choice of the people, and only a certain segment of cases would reach your courtrooms, sir. As I keep saying, with the acceptability of mediation as a cost-effective and time-saving process, the bar has come to recognize mediation as an equally satisfying part of the profession, especially where the law provides either no or less efficacious remedy. This acceptance of mediation across all the fields of law is the heralding of the said golden age, and we must usher it in the same loud shankhnad that we do. On that note, please allow me to welcome all once again. Thank you, and I look forward to a great evening as well as tomorrow's sessions. Jai Hind.
Thank you very much, Mohitji, for your welcome address. As you are aware, ladies and gentlemen, Delhi High Court Mediation and Conciliation Center, Samadhan, was flagged off in the year 2006. At present, this center is fortunate in getting full support, encouragement, and guidance from our patron-in-chief, Honorable Chief Justice of Delhi High Court, Honorable Mr. Justice Satish Chandra Sharma ji. May I now request Honorable Mr. Justice Satish Chandra Sharma for his introductory address, please. Honorable Mr. Justice Satish Chandra Sharma.
Okay. Honorable Dr. Justice D.Y. Chandrachud, the Chief Justice of India. Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India. Honorable Justice Narasimha, Judge Supreme Court of India. Honorable Justice Rajesh Bindal. Honorable Justice Amanullah, Judge Supreme Court of India. Justice Manmohan, Chairman Overseeing Committee Samadhan. Learned R. Venkat Ramani, Attorney General of India. Honorable Chief Justices who have come to Delhi to attend this program. Honorable Judges of the High Court. Honorable former Judges of the Supreme Court. Honorable former Chief Justice and Judges. Shri Mohit Mahathur, President and other office bearers of the Delhi High Court Bar Association. Senior advocates. Shri Chetan Sharma, ASG, judicial officers of District Judiciary, officers and officials of the registry of this court, members of bar, and all others who are in attendance today. I wish you a very good evening. Ladies and gentlemen, today we are honored to have amongst us the Chief Justice of India, who has transformed the way judiciary and judicial process is looked at by our citizens and has instilled a sense of acceptance for innovation and creative thought in administration of justice. We are also elated to have the gracious presence of Honorable Justice Kaul, who is leading the Mediation and Conciliation Project Committee and the National Legal Services Authority on their path of consistent growth. Mediation finds a place in the most successful experiments in the field of administration of justice in India. The exercise of mediation has deep roots in the society. It is born out of societal morality and as it promotes amicable resolution and reduces friction, which form part of our norms and values. Although all forms of resolution or adjudication are meant to secure the end goal of justice between the parties, the process of mediation seeks to achieve this goal at the cost of minimum friction in the society. One may recall that the enactment of procedural laws way back in 19th century and their applications to real-life situations was a challenging phenomenon, primarily for the reason that the society found many of the processes to be unrealistic or unfamiliar. As a result, our process unarguably became more adversarial in nature. In such a scenario, the success of mediation is a story worth telling as it protects the society fabric, and every endeavor to strengthen the same must be welcomed. Delhi Center is, I should not say it because I am right now in Delhi, but the Delhi Mediation Center is one of the best in the country. It started in 2006 as informed, and I received training in mediation in 2009, which was given by Delhi Mediation Center. My trainer was Justice Sudhir Jain, who is now Judge of Delhi High Court. So Delhi High Court gave training all over the country in the field of mediation. This conference is dedicated to mark the January of mediation and to explore the possibilities of refinement, especially in advanced subject matters. Today, the scope of mediation is expanding, and even complex commercial matters are falling within its domain. However, the success rate in complex matters is comparatively low. It is primarily attributable to the absence of an institutional culture for mediation. The confidence of the parties is greatly dependent upon an institutional culture. I am happy to note that during this conference, expert sessions would deliberate upon these areas, and innovative ideas from different quarters would breathe life into this process. I may also note that a dedicated statute on mediation would play a crucial role in promoting institutionalization, as legislative backing would be a reflection of people's faith and would provide a uniform mechanism. With these thoughts, I extend my warm wishes for a smooth conduct of the conference and look forward to the discourse. I am certain that the expertise of our distinguished panelists would not only be insightful for understanding the shortcomings, but would also add immense value to the practice of mediation. I again thank Honorable the Chief Justice of India for sparing his valuable time and joining us here today. Thank you and Jai Hind.
We are grateful to Honorable Chief Justice, Delhi High Court, and Patron-in-Chief Samadhan for his introductory address. Ladies and gentlemen, we are privileged to have with us in this inaugural session of National Conference on Mediation, the Honorable Attorney General of India, Mr. R. Venkatramani. Last year, that is 2022, he took over as the 16th Attorney General of India. With over 4 decades of practice at the Supreme Court, Mr. Venkatramani has specialized in constitutional law, law of indirect taxes, human rights law, civil and criminal law, और ये हमारा सौभाग्य है कि आज आपका मार्गदर्शन हम सबको मिलने जा रहा है. May I now request Honorable Attorney General of India, Mr. R. Venkatramani, with your huge round of applause, ladies and gentlemen, for the special address by Honorable Attorney General of India.
Sandwiched between two visionary and creative judges, Chief Justice of India and Justice Kaul, I asked myself a question: what do I bring to the subject of today's discussion? But then I want to share a few thoughts. Before I do that, some of my experiences as a member of the Supreme Court Legal Aid Committee way back near 1984 to 87 or 88. With a lot of passion, when I became a member, I did not know that the Supreme Court Legal Aid Committee can also be proactive. In the sense, as I began to look at the kind of and the wide range of issues that began to come to the Supreme Court Legal Aid Committee, very slowly it dawned upon me that this is a powerful institution. But how do we use this powerful institution? Not merely as a small tool in aid of litigation in the Supreme Court, but beyond that. This is not the time and the place to chronicle some of the ways we try to engage the Supreme Court Legal Aid Committee in traveling beyond the assistance of the Supreme Court by way of litigation and legal aid. Some of the great judges of our country have thought about legal aid not merely as a court assistance tool. They conceived that legal aid is a tool for social and legal transformation and for equipment of the legal system itself to address some of the most complex questions that will come before it over a period of time. And I gather some of those thoughts and have looked at them and internalized them and tried to find out in what way law as an instrument of social change and the powerful tool of social change can do its best. And in that context, I look at mediation. Before I go further, I want to make some announcements. I suppose these announcements will pave a little foundation for pushing the frontiers of the mediation efforts in our country. Announcement number 1, I propose to set up the Attorney General National Council of Mediators Watch to gather all the experiences of mediations across the country. And it will not be merely an endeavor on the part of the Attorney General, but I propose to involve in this mediation watch the Advocate Generals of all the states, and if possible, a little more wider engagement of very senior members of the bar across the country. Announcement number 2 is little more closer to my heart. I thought it's time for the Attorney General to move forward in this regard. Second one is the Attorney General National Award of Mediators Achievements. So I propose to look at about 5, mediation achievers across the country and to recognize them nationally at a very national level. It's important to recognize achievements. And these 2 very small, humble initiatives on the part of the Attorney General, I thought, would be some kind of an integration of the efforts across the country. I hope I'll be in a position to push these 2 agendas and work with them as much as possible within the scope of my short tenure. And I look forward to the cooperation and engagement of all concerned minds across the country. But I'm too delighted to be here today. I did not know there's going to be a well-informed, enlightened audience here. And Chief Justice of the High Courts, my friend in mediation, who have great achievements over a period of time. And when I looked at the audience, they asked me a question: what is that I can share from my little experiences? But 3 points and 3 issues I would like to probably flag before you. Now, for any idea to receive recognition, the strength of an idea, if this idea itself doesn't have a strength, it doesn't get accepted in the community. The strength of an idea is the first, Second comes the tool that we use for the idea to become acceptable in the community. And the third is cultural involvement in social acceptance of the idea. If these 3 things are absent, I don't think an idea gets really accepted. Look at the great idea of Satyagraha of Mahatma Gandhi. How did it get accepted? There is a cultural acceptance and a cultural milieu available in our country. The acceptance is, a very important tool of social change. So, when I look at, and then therefore an important role to be played by a law as an instrument too. But that role to be played by a law sometimes is very direct, sometimes indirect, sometimes invisible too. So I look at all the three dimensions of the role of a law again and to find out what is that the proposed mediation bill can do, and both directly, indirectly, and in invisible aspects. I think that we need a lot of discussion on that. And secondly, how do we really go about adding strength to the various dimensions of the mediation endeavors in our country? We keep talking about supplementing the justice administration system. I think as long as we are tied too deeply to the adversarial system in our country as the only method of justice administration, I think we are somewhere getting deeply in a wrong direction. It's time for us to move away from the adversarial system in all its sweep, and as if that's the only process that's equipped and best suited for resolving the justice and addressing the justice needs of different sections of a community. And unless we appreciate that the justice needs of different sections of the community are different, and how do we really therefore forge new instruments to address different justice needs, we will be probably having endless dialogues on the failures of the adversarial system. I think probably we had enough of them. And the number game and the pendency, etc., are so well known, but I think we are not still geared towards moving away from the adversarial system. So that's one thing which keeps coming to our mind, and I think we need a larger national and judicial and legal debate on this. Then there's an issue of private mediation, which is also a matter of equal importance. Now, how do we really strengthen people who are passionate, equipped, mentally and culturally, so equipped to play an important task and role in being a mediator? We need a lot of instruments to come to their aid, not merely the legal, the judicial aid. I think something beyond that needs to be pressed into service. So how do we get the wide range of institutions in our country? And what comes to our mind are the law schools and the law colleges. And if the law schools and law colleges can be converted into R&D laboratories, research and development laboratories, it's time we convert them into R&D laboratories. And mediation should be one most important subject for R&D laboratory functioning and subject. I suppose all national law schools, and since judges head almost all the national law schools, why don't we look at national law schools as the most important and immediately available institutions for strengthening the private mediation initiative? How do you go about it? I think a lot of thoughts will come because honorable judges are here and really experienced minds are here. Then I think that the other important aspect is we seem to exclude the political branch of a country from many of these engagements. We look at them as with a lot of disaffection, if you put it like that. Our lack of conviction about the competence and the ability of elected representatives in playing important roles, I think somewhere we need to again look at that. So in aspects like a private mediation or using the law to its highest potential, I think the political branch of a society and is also to be deeply engaged. How do you go about it? One small idea, and it comes again from an experience. When we drafted the construction workers' welfare bill, I had occasion to interact with the petition committee of Parliament over a period of time. And that gave me a lot of invaluable experience. And these committees, I suppose, if we're able to engage these committees at a cultural and an exchange of information level, how do we make each and every one of a state legislative assembly and members elected thereof to be engaged consciously in promoting important initiatives like this? And I think it's possible. And that's why I thought the Attorney General's National Council for Mediators Watch will do all this job. A lot of ideas keep floating in my mind. I suppose I would rather be a better advised to listen and to the Chief Justice and Justice Kaul. And I'm sure with these two ideas I floated, I'll receive a lot of insights and support. And thank you for your attention.
We are grateful to Honorable Mr. R. Venkatramani for his kind and motivating words and for his valuable announcements. दिव्य सज्जनों, लगभग 16 वर्षों की अपनी जर्नी में समाधान ने बहुत सारे सकारात्मक बदलावों की नींव रखी है, उसकी शुरुआत की है। हमारी सोच को बदला है, हमारी अप्रोच को बदला है और इसी का परिणाम है कि आज दिल्ली हाई कोर्ट मीडिएशन एंड कंसिलिएशन सेंटर समाधान देश के लीडिंग मीडिएशन सेंटर्स के रूप में अपनी पहचान रखता है। हमारी इस जर्नी में बेंच की तरफ से जिन विभूतियों का बराबर हमें मार्गदर्शन मिलता रहा है और आज भी मिल रहा है, उनमें एक प्रमुख नाम है ऑनरेबल जज सुप्रीम कोर्ट ऑफ इंडिया, नालसा के एग्जीक्यूटिव चेयरमैन और MCPC के चेयरमैन ऑनरेबल मिस्टर जस्टिस संजय किशन कौल का। At this moment, I will request Honorable Mr. Justice Sanjay Kishan Kaul ji for his keynote address.
Very good evening to Honorable Dr. Justice D.Y. Chandrachud, Mr. Venkatramani, the Attorney General of India, Chief Justice Justice Sharma, Chairman of the Committee, Justice Manmohan, Mr. Mohit Mathur, President of the Bar, other Honorable brother and sister judges, Chief Justices, judges from various courts, my former Chief Justices, Dr. Sharma, Justice C.P. Shah, who guided me in my years here, and people who set up Samadhan and pioneered it from the beginning, Justice Sareen, Justice Mukul Mudgil, Justice Sikri. Prominent members and doyens of the mediation movement, including Mr. Siram Panchu and Sadhana Ramchandran, other members of the bar, ladies and gentlemen. At the onset, I would like to congratulate Samadhan, NALSA and MCPC for their work in advising the dispute resolution process in India. In yet another incredible endeavor, these organizations have put together this National Conference on Mediation at the dawn of a golden age. I am delighted to be here in a court where I have spent more than 30 years, and for Samadhan, which I hold close to my heart. A unique endeavor run by the bar as a matter of trust between the bar and the bench on an appeal made by the then Chief Justice, Justice Kajju, and accepted then by the President of the bar, Mr. Chandiok. All of these people have played a very important role in setting forth and advancing Samadhan to what it is today, a premier mediation institution. I would like to start by sharing an observations from an experience as a lawyer and thereafter as a judge. I have realized that the character and timeline of dispute does not depend on the subject matter of the dispute or the statutes and the case law governing it. It depends on the belief that even though conflicts are inevitable, they too can result in a win-win situation for all parties. In other words, it depends on the mindset of the parties. Choosing mediation as a dispute resolution method is a reflection of the mindset. But this mindset has to be encouraged and supported by requisite expertise. In my opinion, mediation is becoming increasingly popular due to primarily three reasons. First, mediation is a party-driven process. The parties understand that the dispute is theirs, and so the autonomy too should be theirs, and hence find themselves more comfortable in an informal environment sans the legal jargons and technicalities. They understand what is being discussed and not what the lawyers are debating in court and the legal nuances the judge is trying to lay down. Parties have now started appreciating the advantage of mediation as a confidential, voluntary, and time as well as cost-efficient alternative to litigation. Further, the fact is that the parties decide to mediate shows their willingness to amicably resolve their dispute and understand each other's concerns. This leaves the scope of mending their relationships to a point prior to the dispute. For instance, I often see that in matrimonial disputes, parties iron out the creases through mediation and end up living together again or part as non-hostile parties. Second, the mediators are trained to help the parties reach a resolution and discuss issues respectfully. To give a simple analogy, the parties in a mediation are like passengers who have hired a taxi. The mediator is a taxi driver who facilitates the party to reach their destination. While there could be bumps and detours on the way, the mediator helps parties in preserving their personal and commercial relationships by coming up with innovative solutions. Third, a strong mediation movement has ushered in India in the past few years. Referral of disputes to mediation has found place in the Consumer Protection Act, the Companies Act, the MSME Development Act, the Real Estate Regulation Development Act, and even in the CPC in connection with the family disputes. The Commercial Courts Act stipulates mandatory pre-institution mediation before a suit is to be instituted. Further, the Mediation Bill also seeks to promote mediation, particularly institutional mediation, and provide a mechanism for enforcing mediated settlements and agreements. Even internationally, India has taken steps to support the mediation and was one of the first signatories to the Singapore Mediation Convention, which aims to resolve the cross-border disputes and further facilitate international trade. This is somewhere I would appeal to the Attorney General's good office that the bill in this behalf, in which the Supreme Court had done some pioneering work, is pending consideration for a considerable period of time, and we've had the opportunity of interaction with the parliamentary subcommittee also in a different capacity, and we hope that this sees the light of the day sooner than later. The Supreme Court has been active in showing its inclination towards mediation in appropriate matters. For instance, the Supreme Court had appointed a mediation panel in Ayodhya to Ayodhya dispute to explore the possibilities of settlement. Even in Afghan infrastructure, the Supreme Court laid down an illustrative list of matters which may be mediated, such as cases related to trade and commerce, cases where there is a need of continuation of pre-existing relationship, cases related to tortious liability, and consumer disputes. I truly believe that it's not that we are overloaded, so mediation should be done as an alternative dispute resolution mechanism. But I believe it's a superior method of resolving disputes and must be tried over first, because it permits the parties to structure their solutions, which the court cannot do because it is governed by the prevalent legal position. While the mediation movement in this country has already picked up, I would like to discuss a few suggestions that might make mediation a more effective mechanism. The first is the reference to mediation by the judges. It is my opinion that an effective judge is not only one that is able to apply the correct principles of law to a dispute. It is someone who is capable of understanding the nature of the dispute and recommending its resolution in a manner most advantageous to parties involved. This encompasses solving the dispute being litigated in court itself, or referring the same to mediation, conciliation, or arbitration, depending on the questions raised, the competing interests of the parties, and the nature of the relationship. The judge becomes a proactive participant in determining this. The Mediation and Conciliation Project Committee of the Supreme Court of India has published a training manual for referral judges. It contains a list of guidelines which include considering whether the dispute is fit for referral to mediation, determining the choices of parties, determination of forum of mediation, recording of mutual consent. It also contains guidelines of more logistical nature, such as enjoining referral judges to only annex limited documents pertaining to the case with a referral order and fixing appropriate time limits for mediation process. The manual contains the draft referral order as well. In fact, the MCPC has been encouraging judges across the country to go through a training program or a learning program, and many courts have volunteered. I would only request and encourage judges to participate in this process. I believe, having gone through it more than once, that it has helped me to understand the process of litigation better. Maybe in my normal judging process also assisted me in understanding what the parties really require, while we on a pedestal may be doing something which the parties really may not be so interested in. Let us understand. The litigant wants a solution to his problem. He is not concerned with our legal jargon or pages and pages of judgment or our interest in nuance of law and our intellectual satisfaction. We really all exist for him. Coming to the next aspect of role of lawyers in advancing mediation. Abraham Lincoln had urged lawyers to change their mindset in favor of other mechanisms to resolve disputes, stating, I quote, "Discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the nominal winner is often a real loser in fee, expenses, and waste of time. As a peacemaker, the lawyer has superior opportunity of being a good man. There will still be business enough." In this vein, the role of a lawyer is critical to help to transform the landscape of dispute resolution. With mediation becoming more prevalent between parties, lawyers cannot fall far behind. Lawyers may be trained in mediation, which will allow them to offer alternate routes for dispute resolution to their clients, going beyond the adversarial process. To develop such skills, lawyers always have the option of undertaking training made available by several upcoming ADR centers. Most of these sessions have gone online and thus can be accessed as per advocates' convenience. As a move of encouragement, you saw the Lieutenant General announce from this dais itself two of his proposals to encourage this. I think, and coupled with that, the impression with what the Chief Justice and I carry with the interaction with the Parliamentary Subcommittee, I see no reason why there should not be a push for mediation from all stakeholders, including the government. Thirdly, a training of students to understand mediation as an alternative to conventional method of dispute resolution. We need to ensure the education of mediation from the very beginning. Several law schools have begun to inculcate ADR courses and clinics in their curriculum. Mediation centers have also collaborated with law schools for these courses and have been organizing competitions that require students to use their advocacy skills to mediate a dispute. Fourth, training of mediations to maintain quality of mediation. It is important to maintain quality of mediators by conducting regular training programs. Mediators must be trained on skills that are fundamental to mediation, such as impartiality, communication skills, facilitation of discussions, art of balancing interest of parties. The website of the Supreme Court of India contains mediation training manuals and mediation training programs. Sessions and seminars are hosted by various institutions. The mediators must be informed of the ethical conduct, such as avoiding conflict of interest, being neutral, and ensure voluntariness. After all, as judges from every level, we have been trying to go to discussions through the centers which have been set up as modules for improving our skills of education, and same is true of a mediation too. We are already witnessing a pro-mediation movement in India, and this conference is another step forward in that movement, as it encapsulates relevant and timely topics for discussions such as developing an institutional culture for effective mediation in courts, building trust and mindset of the end user of mediation, and preparing for mediation law in India. I look forward to the invigorating sessions tomorrow and believe that the conference will be a tremendous success. Thank you and Jai Hind.
हृदय से आभार ऑनरेबल मिस्टर जस्टिस संजय किशन कौल का उनके कीनोट एड्रेस के लिए, जिसके माध्यम से आपने जो हम सबको एनकरेज किया है, आपकी गाइडेंस जो मिली है, उसके लिए बहुत बहुत आभार आपका। दिव्य सज्जनों, मीडिएशन को लेकर दो पब्लिक पर्सपेक्टिव से अगर हम बात करें तो दो बहुत महत्वपूर्ण बिंदु हैं, एक अवेयरनेस और दूसरा एक्सेसिबिलिटी। और इन दोनों को बेहतर ढंग से लोगों तक पहुंचाने के लिए दिल्ली हाई कोर्ट मीडिएशन एंड कंसिलिएशन सेंटर समाधान ने एक मोबाइल ऐप तैयार किया है, बहुत ही यूनिक है। एंड दिस हैज़ बीन डेवलप्ड बाय इन हाउस मीडिएटर डॉक्टर अभिमन्यु चोपड़ा अंडर द गाइडेंस ऑफ ऑनरेबल मिस्टर जस्टिस संजीव सचदेवा, वो इज ऑन द डायस। मैं निवेदन करूंगा ऑनरेबल चीफ जस्टिस ऑफ इंडिया डॉक्टर जस्टिस डी.वाई. चंद्रचूड़ से कि वे रिमोट का बटन दबाकर इस मोबाइल ऐप को यहाँ पर लॉन्च करने की कृपा करें।
Welcome to the new Samadhan mobile application. The app is vibrant and dynamic, currently for the Android devices. The app gives a one-click access to certain key features of the Samadhan website, such as cause list, calendar, explanation of mediation, why to choose mediation, details of the High Court Committee, and access to limited reading material. The app also allows for the sign-in feature for the authorized mediators to log in and get a host of additional features, such as to view the individual calendar, assign dates, set up calendar invites for matters, assignment of mediation rooms, view individual caseloads, and sample templates. Certain unique features of the website and the app is that the backend also allows for the mediation court staff to create matters and assign and control the staffing of mediators, besides being able to access real-time statistics of the pendency of matters. This app is just a small preview for the host of new features which will be integrated soon. Thank you.
So this is the unique mobile app, Samadhan. In this inaugural session of a national conference on mediation, now we are going to witness a historic initiative in the form of an MOU between Delhi High Court Mediation and Conciliation Center Samadhan and Uttarakhand High Court. इस MOU के जरिए न सिर्फ उत्तराखंड हाई कोर्ट में मेडिएशन के जो प्रोसेस है उसको और गति मिलेगी, विस्तार मिलेगा, बल्कि दूसरे हाई कोर्ट्स के लिए और दूसरे मेडिएशन सेंटर्स के लिए भी वो एक यूनिक मॉडल होगा जिसको वो फॉलो कर पाएंगे। मैं निवेदन करूंगा उससे साइन करने के लिए MOU को आई विल रिक्वेस्ट द रजिस्ट्रार जनरल ऑफ दिल्ली हाई कोर्ट श्री रविंद्र डुडेजा जी एंड रजिस्ट्रार जनरल ऑफ उत्तराखंड हाई कोर्ट विवेक भारती शर्मा जी एंड ऑल्सो द ऑर्गेनाइजिंग सेक्रेटरी समाधान वीना रल्ले जी टू कम ऑन द स्टेज फॉर द साइनिंग ऑफ दिस MOU बिटवीन समाधान एंड उत्तराखंड हाई कोर्ट। लेडीज एंड जेंटलमैन, सो MOU साइन होने के बाद अब मैं निवेदन करूंगा चीफ जस्टिस ऑफ दिल्ली हाई कोर्ट ऑनरेबल मिस्टर जस्टिस सतीश चंद्र शर्मा और चीफ जस्टिस ऑफ उत्तराखंड हाई कोर्ट ऑनरेबल मिस्टर जस्टिस विपिन सांगी जी टू एक्सचेंज दिस MOU between the Delhi High Court Mediation Conciliation Center Samadhan and the Uttarakhand High Court, ladies and gentlemen. And now you can put your hands together to wish all the best for this MOU between these two entities. समाधान का यह विस्तार है और उसको गति मिलेगी अलग अलग राज्यों में, इस माध्यम से लोगों के जीवन में और बेहतर खुशहाली आएगी। बहुत सारी शुभकामनाएं। दिल्ली हाई कोर्ट मेडिएशन एंड कंसिलिएशन सेंटर समाधान और उत्तराखंड हाई कोर्ट के बीच साइन हुए इस MOU के लिए बहुत सारी बधाई और शुभकामनाएं। आभार ऑनरेबल मिस्टर जस्टिस सतीश चंद्र शर्मा जी, ऑनरेबल मिस्टर जस्टिस विपिन सांगी, दिल्ली और उत्तराखंड हाई कोर्ट्स के रजिस्ट्रार जनरल्स रविंद्र डुडेरा जी एंड विवेक भारती शर्मा जी और वीना रली जी। दिव्य सज्जनों, मेडिएशन के जो अलग अलग आयाम हैं, जो उसके अलग अलग एस्पेक्ट्स हैं, उसको लेकर हमने एक बहुत ही यूजफुल और इन्फॉर्मेटिव एक बुक तैयार की है, मेडिएशन एंड इट्स प्रॉमिस। समय है इस बुक के रिलीज का, और इसके लिए जो बुक जो है उसकी कॉपी इट विल बी प्रेजेंटेड टू द डिग्निटीज ऑन द डायस। एंड फर्स्ट ऑफ ऑल आई विल रिक्वेस्ट जस्टिस नवीन चावला, द जज दिल्ली हाई कोर्ट, he will be presenting a copy of the book to Honorable Chief Justice of India, Dr. Justice D.Y. Chandrachud, and Justice Vikas Mahajan, Judge Delhi High Court, he will present a copy of the book to Justice Sanjay Kishan Kaul, Judge Supreme Court of India. The first copy to the Honorable Chief Justice of India. Justice Vikas Mahajan, he will present a copy to the Justice Sanjay Kishan Kaul, Judge Supreme Court of India. Sadhana Ramachandran ji, advocate, she will be presenting a copy to Mr. R. Venkatramani, Attorney General of India. Sudhanshu Batra ji, senior advocate, I will invite you also to present a copy to Justice Satish Chandra Sharma ji, Chief Justice of Delhi High Court. Sudhanshu Batra ji. Veena Rally ji, Organizing Secretary, I will request Veena ji to present a copy to Justice Manmohan, Chairman, Samadhan. And I will invite Rajiv Virmani ji, Senior Advocate, to present a copy to Justice Sanjeev Sachdeva, Member of Overseeing Committee. And I will invite Mitali Gupta and Radhika Dubey ji to present a copy to Mr. Mohit Mathur, President, Delhi High Court Bar Association. So please put your hands together to wish the best for this publication. Mediation and its promise. Thank you very much. We are grateful to Honorable Chief Justice of India and all the dignitaries on the dais who have released this book. दिव्य सज्जनों, ये हम सब जानते ही हैं, अच्छी तरह से जानते हैं कि ऑनरेबल चीफ जस्टिस ऑफ इंडिया डॉक्टर जस्टिस डी.वाई. चंद्रचूड़ न्याय के जिस स्वरूप को लेकर हमेशा हमको मोटिवेट करते हैं, उसके केंद्र में है मानव की गरिमा, द डिग्निटी ऑफ ह्यूमन बीइंग्स। एक ऑल्टरनेटिव डिस्प्यूट रेजोल्यूशन प्रोसेस के रूप में मीडिएशन भी इसी को केंद्र में रखकर अपनी पूरी प्रक्रिया का संचालन करती है, उसे कंडक्ट करती है, जहां मानव की गरिमा को, उसकी डिग्निटी को संरक्षित करने का प्रयास होता है। हमारे लिए बहुत ही गौरव से भरा हुआ क्षण है। आज पुनः हमें मार्गदर्शन प्राप्त करने का मौका मिलने जा रहा है ऑनरेबल चीफ जस्टिस ऑफ इंडिया से। मे आई नाउ रिक्वेस्ट with a huge round of applause, ladies and gentlemen, Honorable Chief Justice of India, Dr. Justice D.Y. Chandrachud, for his presidential address. Honorable Chief Justice of India.
My distinguished colleague and friend, Justice Sanjay Kishan Kaul, my very distinguished colleagues in the Supreme Court, Justice Narasimha, Justice Bindal, Justice Amanullah, I must make amends in absentia by referring to Justice Hema Kohli, because the last time my dear sister pulled me up for having missed her presence in the audience. But I say that in absentia because I don't see that she is around this evening. The Learned Attorney General for India, Sri R. Venkatramani, Chief Justice Satish Sharma, Chief Justice of the Delhi High Court, Justice Manmohan, all his colleagues in the Delhi High Court, Chief Justices of various High Courts, judges of various High Courts, former judges, Chief Justice A.P. Shah, who is here not only in his own right as a former Chief Justice of the Delhi High Court, but because his spouse, Swati Tai, is a very dedicated and a committed counselor in her own right. Justice A.K. Sikri, who's been a mentor to me. Justice Mukul Mutkal, with whom I learned the initial ropes of the legal profession when he was an advocate on record in the Supreme Court, and we were so closely associated with Dr. Chitle's chamber. Mediators, Sriram Panchu, I still have your book on mediation in my own library, which you presented to me when I was a judge of the Bombay High Court. Sadhana Ramchandran, and through all of you, the family of mediators, distinguished guests. The learned Attorney General for India made 2 announcements. I was delighted to hear them, but I was waiting for the 3rd announcement, which never came. By my very position, I'm now out of running as a shadow Attorney General, but I can make the 3rd announcement nonetheless, which is that the motto of the Union government and its agencies should be mediate, don't litigate. Well, today marks a very special day as we celebrate the birth anniversary of Dr. Bhimrao Babasaheb Ambedkar, the father and chief architect of the Indian Constitution. India's constitution was drafted in the aftermath of a long and bitter struggle for independence. The framers of our constitution recognized the need to create a document which would be reflective of the will and the aspirations of the people. The task before our Constituent Assembly was to transcend divergent positions on particular issues and create a framework for a common institutional life in the nation, resolving the many disagreements. Constitution drafting and mediation are 2 processes that may seem unrelated, but they continue to be intertwined as they share many normative goals. The processes of dialogue, negotiation, compromise, and consensus building form the bedrock of the making of the Indian Constitution. Diverse interests of stakeholders, all working towards the common goal of making independent India a resilient constitutional democracy, was successfully mediated through the countless deliberations of the Constituent Assembly. Similarly, mediation is a process that involves resolving disagreements by facilitating an open dialogue, mutual understanding, and bringing together stakeholders with differing viewpoints and helping them to find common ground. In both cases, the goal is to create a framework that is inclusive and reflective of the values and aspirations of the people involved. Particularly in today's fraught times, mediation has an important message for us as citizens. Are we losing the ability to talk to each other across the spectrum? Are we losing our ability to engage in reasoned dialogue? And is it not necessary, therefore, that we pick up something from mediation, which is, importantly, being good listeners, understanding the other's point of view, and not only insisting that the dogma which we espouse is the only dogma which is relevant to the times? Mediation is one of the oldest and most common forms of third-party intervention in a conflict, with a stated purpose of resolving the conflicts through negotiation. When mediation was first introduced as one of the dispute resolution mechanisms, it was heralded as a game changer in the Indian legal world, since being the least formal of dispute resolution mechanisms, it had the potential to provide timely and affordable justice to all and reduce the burden of the burgeoning judicial caseload. In jurisdictions like India, where we hold values such as trust, community, social harmony, and good relations on a high pedestal, mediation's ability to envisage an alternative conception of justice, which is more personalized, inclusive, and democratic, cannot be understated. Mediation is seen as a means of serving the rule of law. The transformative characteristic of mediation is that it is a process which puts the decision-making authority in the hands of ordinary people, empowering them, those people who are involved in disputes. Mediation offers citizens a forum to not only determine the outcomes of their disputes, but also determine the criteria and standards by which those outcomes are evaluated. For each and every pair of parties, this criteria changes depending upon their own lived experiences. Seen in this light, mediation holds the potential to change the way we understand justice itself, from an adversarial formal process tailored towards a zero-sum outcome to a more collaborative, interest-based process focused on enabling parties to move forward constructively. So mediation, in other words, is much more than a movement to declog the courts. When the government, which is the largest litigant, mediates, it sends a message that in the framework of the law, the government is not an adversarial opponent to our citizens. The government must adopt the robes of a friend, partner, and a problem solver, be it in terms of business or communities or families. When citizens are encouraged to mediate, our societal framework and institutions value the quality of our processes and the subjective acceptability of the outcomes. Every Monday and Friday, which are usually miscellaneous days in the Supreme Court, we as judges refer a number of matters to the Supreme Court Mediation Center, be it a matrimonial dispute, a child custody matter, or a commercial dispute for determining pendency of electricity dues. Since I took over as Chief Justice of India in November last year, there were about 3,000 transfer petitions which were pending in the Supreme Court. Now, transfer petitions typically involve matrimonial cases. Not all of them are matrimonial. Some arise in criminal cases. Spouses are located in two different parts of the country, and they don't speak to each other. The marriage has run into the difficulties of the stresses of the IT software industry, or just plain lack of tolerance in the age in which we live today. And these have now become fertile grounds for references to the Supreme Court Mediation Center. And what we have realized is exactly to the contrary to what was assumed would be the role of lawyers when they act as mediators. Lawyers were regarded as people who were so formalistic in their training that they would not be willing to accept mediation. But some of the finest outcomes which we have generated are through the Supreme Court Mediation Center itself. One of the favorite stories which I have is about my own role as a judge mediator in the Bombay High Court. Now, judge mediators are of two kinds. You have judge mediators who believe that as mediators they can deliver outcomes to parties, and whoever says no to the outcome loses in the case if it goes on merits. That's not what mediation is about. We had a very distinguished judge of the Bombay High Court who gave you what he thought was a perfect mediated solution, mediated by one person, the judge, without reference to the parties. And there is the other type of judge mediators who are collaborative. They are reasonable. They invite parties to resolve their disputes. So on one such afternoon in the commercial court of the Bombay High Court in those days, I had a dispute between a very good family, well-heeled, well-resourced. They were in the transport business. The brothers were at loggerheads, and I spent the whole afternoon mediating. Towards the end of the evening, when the settlement was signed and was all done and dusted, I heard someone singing in my court. Now, that is not something exactly which you want to hear in a court. So I heard some voice of a fairly aged woman singing in my court. So I asked the court master, what is this that is happening? But before the court master could answer or go and stop the person from singing, one of the parties in the dispute said, "Sir, I'm so sorry. That's my mother. We brothers have been lost in this litigation for the last decade. She's just singing a bhajan for you to bless you for what you did by resolving this dispute." So along the way, you also acquire the blessings of the parties. In this case, it was a 90-year-old woman. Perhaps those blessings have led me to where I am today. Our goal is to ensure that parties are able to resolve their disputes and get justice at the earliest. Our courts recognize that justice can be accessed both inside and outside the courtroom, and becomes the duty of the judge to ascertain whether the issues in dispute could best be resolved through mediation or if other resolution mechanisms would be more appropriate. I'm happy to note and to have had the opportunity to release the book Mediation and Its Promise, which features excellent articles from experts on mediation across the bar, the bench, and the academia. I was perusing, incidentally, the statistics mentioned in the latter parts of the book and was pleasantly surprised to see the diversity of cases which were being handled by Samadhan. Over the last 17 years, the Delhi High Court Mediation Center has settled commercial cases, matrimonial cases, IPR disputes, as well as industrial disputes. There is also a chunk of cases categorized in the nebulous other category, of which I'm intrigued to know the specifics. The scope of using mediation as a problem-solving approach to conflict management has been continuously expanding in every context in which a conflict may arise. I was amazed by the beauty of this book, including its cover. But I must also share with you that one of my prized possessions is the calendar of Samadhan, which finds a place on my table, both at home and in the office. And I resist the temptation of turning all the 12 pages at one go. I wait for the next month to come to turn the page, and the Samadhan calendar has this beautiful quotation on mediation, which, of course, a judge in me loves, but even my spouse, who's a non-lawyer, dotes on. Family disputes and commercial disputes are two areas that could not be more different, but mediation has proven to be a success story in both these areas. Mediation is the most suitable when there is potential for preserving an ongoing relationship. In commercial matters, where the focus is on accommodating the rigors of commercial complexities, mediation allows the parties an opportunity to develop a creative outcome which benefits their commercial reputations and monetary interests. As commercial disputes are giving way to greater and greater complexity, when I was part of the bench in Ayodhya, I thought that having a 30,000-page record was exceptional. In the Supreme Court, now you find that a 10,000-page record is par for the course. Such is the commercial complexity, whether it's in context of electricity disputes or environmental disputes or just pure commercial disputes. So given the commercial complexity of litigation, it's all the more reason that mediation should become the first and the more desirable alternative to litigation. The Singapore Convention on Mediation, providing for a framework to enforce cross-border mediated settlements, has made mediations an attractive option even in complex international commercial disputes. Family mediation involves engaging with some of our closely held community values in concrete and difficult ways. Women, especially those belonging to marginalized communities, have often found formal legal proceedings to be alienating, having been historically prevented from accessing law on an equal footing. To mitigate their alienation, dispute resolution mechanisms such as mediations, where parties express their grievances directly, take a step forward in making the law less intimidating. Mediation confers an avenue for citizens to chart a path forward in the interpersonal relationships in ways that the law denies to them. However, it would be incorrect for me to say that mediation as a method does not suffer from its own iniquities. One fundamental dilemma that mediators have to constantly deal with is to define their own role as mediators. A mediator is supposed to be a neutral third party. Mediators exercise substantial discretion in deciding when mediator interventions are necessary to facilitate party interactions, and in doing so, they may influence not only the process of mediation, but also its outcome. So what does neutrality mean? Generally, it is understood to mean that the mediator should act impartially, treating both the parties in an even-handed manner. However, in situations where there is unequal bargaining power between the parties, such an understanding of neutrality may lead to the dialogue and mediation to occur between two unequal parties, leading to unjust outcomes. A perceptive quote is that a mediator who remains aloof during a negotiation in order to maintain their neutrality is like a car which is stuck in neutral. It just don't go anywhere at all. An ethnographic study conducted in the family courts at Kolkata revealed that the tendency in divorce mediation was to work towards the goal of preserving marriage and reuniting or reconciling the couple. This could be understood as a patriarchal bargain, where the women in male-dominated societies, instead of resisting patriarchal and gendered norms, try to maximize their options within an inherently unjust system. In the hands of an untrained mediator, such a reunion of a couple might cause more harm by pushing the underlying interests of the parties to the back burner instead of actually healing the fractured relationship. A skillful mediator who is committed to ensuring justice to their clients would be conscious of their own biases and be open to the perspective of others. This self-reflectiveness would enable the mediator to actively monitor how they are intervening in the process, guided not by a pretense of neutrality, but by the principle of maximizing party control given their unique context. In the example before us, it might involve facilitating the negotiation by advising the female client who lacks relevant information regarding their legal rights, or otherwise by openly asking parties to commit to achieving just outcomes, or by providing support to a party struggling to conceptualize an alternative. My intent in flagging out these issues is to strengthen the process of mediation by hoping to initiate a dialogue regarding the issue of accountability and power between different systems of ADR. Merely changing the way of resolving disputes or inserting an informal dispute resolution into formalized legal structures by itself cannot be transformative if we do not alter the logic of unjust values within legal or social structures. As we come together at this conference to exchange ideas, explore new possibilities, and share our experiences, we stand at the dawn of a golden age of mediation. Mediation's promise has never been greater, and as we look to the future, mediation should not be considered to be just an alternative dispute resolution mechanism, but the preferred method of conflict resolution. The A in ADR, in other words, ought to stand for appropriate instead of alternative. The support of the government and the judiciary in establishing mediation as a viable parallel process is one of the reasons for the growth of mediation in India. The legal framework has continued to evolve to support and institutionalize a well-developed legal framework for mediation. The 2018 amendments to the Commercial Courts Act introduced mandatory pre-institutional mediation in disputes of commercial nature, particularly Section 12A. Mediation is also provided for in legislation relating to real estate, consumer protection, and corporate law. Recently, the Union Ministry of Law and Justice constituted a working committee for drafting rules and standards of mediation. The Mediation and Conciliation Project Committee, established by the Supreme Court in 2005, has been successful in promoting the use of mediation and other forms of ADR. The committee has undertaken steps to lay down model mediation codes, facilitate training of mediators across the country, and regulate the process across all the districts. The committee is in the safe hands of my distinguished colleague, Justice Sanjay Kishan Kaul. The national and state legal services authorities have played an instrumental role in encouraging settlement of disputes through ADR. They regularly organize mediation training workshops for lawyers. The development and continuous training of mediators is important to ensure the success of the mediation movement. It is imperative that we equip our young generation with necessary knowledge and tools to resolve conflicts in a peaceful and constructive manner. There are various effective youth-based mediation programs available that provide young people with necessary support and resources. One such initiative is the Community Mediation Service Program, which trains young people to become mediators and teaches them how to handle conflicts in their communities. These programs empower the young to work out problems independently, building self-respect and promoting empathy for differing perspectives. In the international sphere, peer mediator programs are prevalent in educational institutions where students are trained as mediators to handle conflicts that may arise among themselves or between students and teachers. These programs not only help in conflict resolution, but also promote a sense of responsibility and leadership among the youth. One of the serious problems of the young today in our society are our short attention time spans. Mediation, by encouraging youngsters to be active listeners, can perhaps stretch those dying and short time spans. As we look towards the future then, law schools can play a pivotal role in promoting mediation as an effective alternative to traditional dispute resolution mechanisms. Law schools must incorporate mediation training into their curriculum, focusing on developing the skills necessary for effective mediation, such as active listening, problem solving, and negotiation. Establishing mediation clinics that provide students with practical experience in mediation under the guidance of experienced mediators can be an effective way to achieve just this. Law schools can also conduct training programs to equip students with mediation skills and organize mediation competitions to promote and encourage students to participate in alternative dispute resolution and hone their mediation skills. Mediation is an essential tool for future lawyers, and law schools have a responsibility to prepare their students for the changing legal landscape. Youth-based mediation programs and law school mediation training programs will not only train the next generation for a career in a law where opportunities are bound to increase, but it can also help them build necessary skills to resolve conflicts in a constructive and peaceful manner, promoting empathy, leadership, and responsibility among the youth. For mediation in India to reach greater heights, we need to ensure that mediation programs continue to evolve and become even more responsive to the needs of parties. The use of technology offers a great opportunity to revolutionize the mediation space. Personally, while I have been a supporter of harnessing technology to improve judicial processes and access to justice, for the longest time, I still had my doubts about online mediation. I think all of us feel that intuitively, mediation will be successful only if we have parties sitting together in the same common room. In fact, that was the reason why two of my colleagues, Chief Justice Deepak Mishra and Justice Khanvilkar, held that, well, there cannot be online mediation in family disputes, and I was the dissenter in that case. While there may be some truth to what the majority said, I was surprised to see the data from Samadhan discussed in one of the chapters of the book we are releasing, which discusses how the online mediation project was a game changer during the pandemic. The percentage of settlements in commercial disputes during this period was considerably more than those witnessed in the offline pre-pandemic settings. Online mediation has also made it considerably easier for parties who are located in different cities, states, or even countries. The typical spousal relationship where one spouse is in Gurgaon, the other one is in Silicon Valley or in Bangalore or wherever else. Or at the Supreme Court, we have seen multiple matrimonial and child custody disputes with one party in India and another abroad that we have been able to refer to the Supreme Court Mediation Center with the advent of online mediation. By exploring and adopting innovative approaches and technologies, we can increase efficiencies in the process of mediation and expand the reach of mediation services. In terms of the use of technology, I do not mean only promoting mediation through video conferencing, as that is only the most basic manner in which we can use technology. Rather, I want to draw everyone's attention towards the larger gamut of possibilities in the field of ODR, or online dispute resolution. The Niti Aayog Agami Stakeholders Meeting on Catalyzing Online Dispute Resolution in India in 2020, which I had the opportunity to participate in, brought to my notice the potential of ODR in changing the dispute resolution ecosystem by revolutionizing it. The potential of ODR in providing a range of dispute containment and dispute avoidance services, in addition to dispute resolution services, is immense. Online dispute resolution platforms and tools have been successfully used in countries like Canada and the Netherlands to increase access to justice and expand the reach of mediation services. These platforms and tools leverage technology to provide a range of services, such as online mediation, video conferencing, and chatbots to help people resolve disputes. These ODR services would go beyond traditional mediation and involve the integration of technology to build automated case flows and case management systems. The field of ODR provides opportunities for reducing both time and cost of dispute resolution. A glimpse of the potential of ODR was seen in the success of the e-Lok Adalats conducted by various state judiciaries during the pandemic. For instance, in 2020, when the Delhi State Legal Services Authority conducted an e-Lok Adalat, it led to the disposal of over 8,000 cases. This shows the scope of mediated settlements in disputes which otherwise add to the pendency before the courts. Industry-specific mediation or the application of ODR, such as its use by the insurance sector to settle disputes related to insurance claims, or by the banking sector to settle disputes related to lending, promises to not only decrease litigation costs for these industries, but will also declog the judicial infrastructure. Building ODR mechanisms to resolve commercial contractual disputes will go a long way in improving the ease of doing business rankings in India. The Government of India, which is the single largest litigant before the courts, may also benefit from strategically adopting ODR mechanisms across many of its departments by attempting to settle disputes related to the provision of various citizen-centric services, as well as in employment issues such as pension-related grievances, which often end up traveling all the way till the Supreme Court. The potential of saving taxpayers' money by avoiding the use of courts' resources, as well as the litigation costs for the government, by instead settling such disputes through ODR can be enormous. In 2017, the government had taken up the action plan to reduce governmental litigation. ODR can be an important step in that direction. Almost every day at the Supreme Court, we witness a peculiar category of cases. The parties in these cases do not have much issue with the amount of the claim being awarded, be it an insurance claim or an employment claim. However, despite coming all the way to the Supreme Court, they do not wish for it to be recorded as a precedent for future cases. The lawyers always tell you, please say in the facts and circumstances of this case. They want to insist that these settlements are in the specific facts and circumstances, and they do not want it to be a legal obligation binding them in the future. All such cases, to my mind, are prime examples of disputes that would have been fit for a mediated settlement through ODR and need not have traveled through multiple levels of the judicial hierarchy. The report of the Justice Sikri-led Niti Ayog's expert committee on ODR has brought out in detail the steps that can be taken for catalyzing the growth of the ODR ecosystem. The lack of provisions allowing digitization of notarization of documents and the requirement under state rules of attaching e-stamp certificates to documents, despite the central government's introduction of e-stamping, creates barriers in an otherwise end-to-end online process. As an initial step, we must focus on removing all such barriers that are coming in the way of ODR's promise in improving the justice delivery mechanism. I once again congratulate the organizers of the Delhi Mediation Conference for putting together this extremely important initiative. One of the major challenges to the adoption of mediation and ODR is the lack of awareness regarding the benefits that these options provide. Such conferences and consequent public awareness campaigns are the only way for us to build public confidence and increase the uptake of these mechanisms of dispute resolution. Last word then. I often say that as judges, we need to be careful that when we judge others, because that is our job, we must do so without being judgmental of others. In a similar vein, for all mediators out there, I would advise everyone to borrow a life lesson from the OTT football coach, Ted Lasso. Be curious and not judgmental. A mediator with curiosity notices what was said and done by the parties, names what was seen, and invites the parties to also become curious about their underlying motivation and interests behind a particular action. Through our years of practice in the legal setting, I think we have all learnt by now the dangers of rushing to judgment on possibly incomplete facts and reaching a premature diagnosis. Curiosity fixes this rush to judgment, as it requires a person to be a patient yet active listener, converse broadly with the parties to draw out all relevant facts, and to inquire about the underlying goals or intention. So as I close, I urge each and every one of you to embrace curiosity. Curiosity piques interest and improves engagement with the world, arousing skepticism and inspiring formulation of questions, which are then sought to be answered by an equally persistent and curious mindset. Whether you are a judge, a mediator, or a student of law, or simply a member of society, we all have a role to play in creating a more just world. Let us strive to be curious, to understand one another, and to approach each situation with an open mind and an open heart. Thank you very much. Thank you.
Thank you very much, sir, for your kind words. आपका एक एक शब्द हमारे लिए मीडिएशन की हमारी इस जर्नी में हमारा मार्गदर्शन भी करेगा, हमें रोशनी दिखाएगा, सही दिशा में आगे बढ़ने की प्रेरणा देगा। देवी सज्जनों, मैं निवेदन करूंगा ऑनरेबल जज दिल्ली हाई कोर्ट और चेयरमैन ओवरसीइंग कमेटी समाधान मिस्टर जस्टिस मनमोहन से कि वे फॉर्मली आपका आभार भी व्यक्त करें और साथ ही साथ इस नेशनल कॉन्फ्रेंस का एक ओवरव्यू भी आपके साथ शेयर करें। ऑनरेबल मिस्टर जस्टिस मनमोहन।
It's always a difficult act to follow the Honorable Chief Justice of India, and even more difficult to follow a scholar Chief Justice of India. But I'll make an effort. Respected Chief Justice of India, Dr. D.Y. Chandrachud, Justice Kaul, Executive Chairperson of NALSA and Chairman of Mediation and Conciliation Projects Committee, Judges of the Supreme Court, Attorney General Mr. Venkat Ramani, Justice Satish Chandra Sharma, Chief Justice, Delhi High Court, the Chief Justices of Chhattisgarh, Jammu and Kashmir and Ladakh, Karnataka, Meghalaya, Sikkim, Uttarakhand High Courts, the Acting Chief Justices of Calcutta, Gujarat, Himachal Pradesh, Tripura High Courts, my brother and sister judges from Delhi and outside Delhi, former Chief Justices and Acting Chief Justices of Delhi High Court, past chairpersons of Samadhan, Mr. Mohit Mahathur, President of the Bar, advocates who have been nominated by other high courts, our esteemed panelists who have traveled from India and abroad, mediators, trainers, friends, and all the members of the mediation fraternity. Distinguished guests, ladies and gentlemen, it's my privilege to welcome you to the National Conference on Mediation under the aegis of NALSA and MCPC in my capacity as Chairman of the Overseeing Committee of Samadhan. Samadhan was established in 2006 when Justice Kardju was the Chief Justice of the Delhi High Court and Mr. Chandok was the President of the Delhi Bar Association. Mr. Justice Manmohan Sareen was the first chairperson of Samadhan, and it was they who, along with Justice Sikri and Justice Mudgal, who conceptualized and created a unique model of collaboration between the bar and the bench. To administer this mediation center, as also to address the anxiety of the lawyers who thought that mediation would lead to drop in their revenue earning. Samadhan is administered on a day-to-day basis by the lawyers, but it is overseen by a committee comprising of the judges and senior members of the bar acting as facilitators and Sherpas. The Delhi High Court Bar Association continues to support the cause of mediation. Today, Samadhan has trained more than 300 lawyers as mediators, and a long list of applicants are still in the waiting. The training at Samadhan is a blend of theory and practice and much beyond the usual training of 40 hours. After the first phase of the training, the prospective mediators have to work under trained mediators and get practical knowledge of holding the process and writing a settlement which is legally implementable. Thereafter, they again undergo another training before they are impaneled as a mediator with Samadhan. Samadhan, on its panel, has mediators who are domain experts, be it intellectual property rights, family, or commercial law. Even COVID has not deterred us. Samadhan has held online mediation through COVID period and reached out to the distressed people and helped them to resolve their disputes. Online mediation is still going on, and distance is no more a barrier in holding mediation. I think speaking about Samadhan may not be enough, as seeing is believing. So let us see the journey of mediation since its inception in this short film.
Legal cases in India can often be complicated, especially when they involve relationships that are emotionally charged or when they are based on complex contracts. The volume of cases has created a challenging environment for the courts, resulting in pending cases and uneven distribution of justice, where only one party wins and the other loses. Samadhan was established in May 2006 as a joint initiative of the bench and the bar of the Delhi High Court, committed to mediation as a method of alternate dispute resolution. Justice Markanday Kardju, the former Chief Justice of the Delhi High Court, envisioned for the establishment of Samadhan with great determination.
When I set up the mediation center in Madras High Court and then Delhi, there was a lot of opposition by the lawyers. They thought that their practice will go down because instead of clients coming to them, they will go to the mediation center. So their income will be reduced. But then later on it was realized that that is not correct.
Over the years, mediation has proven to provide a neutral ground where parties in conflict discuss their issues, express their concerns, and work towards finding a mutually agreeable win-win solution outside the courts. Justice Kardju's vision of mediation was supported by the then president of the Delhi High Court Bar Association, who paved the way for its success as a trusted dispute resolution process today.
The initial stages when we were establishing this center, all were assigned duties that we took upon ourselves, that every day we'll monitor what is happening in the mediation center. It's a joint venture between bench and bar. That's what you see Samadhan today.
Justice Manmohan, chairperson of the overseeing committee guiding the growth of Samadhan Mediation Center.
We don't interfere in the day-to-day decision-making process, but we just give them guidance, and if they require any facility or any infrastructure, we try to provide it.
Samadhan facilitates conflict resolution between individuals or parties by enabling communication with the assistance of a trained mediator. People can approach the centre directly at the pre-litigation stage or referred by the Delhi High Court, Supreme Court or other courts and tribunals.
To accept a voluntary method of dispute resolution, which is mediation, it requires a special skill of a judge, and it is a very, very important role because the judge grooms the parties into understanding the process of mediation, realizing the benefits of the mediation.
Mediators do not provide solutions or advice to the parties involved in a conflict. Instead, they create a neutral and safe environment where they can work together to find a mutually beneficial solution.
This is the beauty about mediation. It is very challenging, that is why, because you are not supposed to be telling them how you may think, this should be the perfect, this is the way they should be settling, but you can't say this to them.
Samadhan is run and overseen by a committee of judges and lawyers. Mediators on the panel of Samadhan are members of Delhi High Court Bar Association, who have undergone extensive training to learn the art and skills of mediation.
With the senior mediator, our trainees have to finish at least 10 successful mediations. It has made all the difference to the quality both of our mediation as well as our inter-se relationship amongst the mediators.
They work on helping to resolve various disputes, ranging from business deals, property issues, and consumer problems to job disputes, accidents, family problems, and even those involving government departments and organizations.
हाई कोर्ट ने मेरा केस समाधान के लिए मेडिसिन सेंटर में डाला, जहाँ पे मेरा 2-3 महीने में ये सेटल हो गया केस.
So once a mediator settles a matter and writes a settlement, we have a scrutinizing committee and they vet the settlement agreements. The courts also read the settlement to finally see that the settlement is enforceable and is lawful.
Samadhan has come a long way since its inception in 2006. It started with 2 small rooms, but as the number of referred cases increased, more rooms were added on the ground floor and the first floor of the extension block. By 2013, a state-of-the-art mediation center was established with a large reception, an administrative room, a library, 12 mediation rooms, a psychologist room, a children's room, and waiting rooms for beneficiaries.
The system has now sunken in the hearts and people are receptive to it, not as a total substitute, but definitely as an alternate supplemental to the court litigation.
While the far-sightedness of the committee led to the implementation of video conferencing for mediation in 2017, its true value was realized in 2020 when the pandemic hit.
In Delhi, we specially ensured that proceedings were held and parties were comfortable, and we also learned how we could use technology to conduct confidential proceedings.
They are now planning to build a database that can be used for analysis and research, which will be linked with the court server, ensuring a high standard of privacy.
In 2006, when we started mediation, people used to confuse mediation with meditation, and it took us a lot of time to explain what we do is mediation and not meditation. But in today's time, when we see happiness on the faces of the parties, when they go out of the mediation room after resolving their matters through the process of mediation, we feel the pleasure they get is the same as they get in meditation.
I was able to overcome my negative emotions. I was able to deal with them in a healthy environment. And, I would say my mediator really helped me out because, she created that environment wherein, I could go and tell her whatever I felt like.
We had a difficult family case which was referred to Samadhan, and because of the absolutely excellent work by the mediator, the parties would come to a resolution within a very reasonable period of time and a very satisfactory outcome.
We were lucky enough to be referred to Samadhan. We had fantastic mediators who held our hands and walked us through the complicated and sometimes highly emotive mediation process.
If one sits with that kind of mindset that one needs to resolve the issue, then it is absolutely the perfect place to get your matter settled.
There was one particular case in which a single mother was involved, and through adjudication it would have taken her years, and it would have been mentally and emotionally and economically exhausting for her. Through mediation she was able to get what she wanted in short span and with complete satisfaction of both the parties.
Most of my practice is family law, so there's a lot of family disputes that I've referred to mediation center, and it's about 75% of them got settled, which is a great number. And the remaining 25, even if they did not get settled, the client came out and they told me that this is a very good platform.
If you want the mediators to ultimately make a living out of it, how can you exclude private mediation? So in certain commercial disputes especially, or private disputes where parties are able to afford mediation or litigation for that matter, I see no reason why private mediation should not play a role.
I have a word for the stakeholders. Referral judges have to look at mediation as not just a tick in the box, but as part of a mission to persuade parties to take to mediation as the first line of solutions to the problems which they encounter. I believe civil society has to be encouraged to take recourse to mediation, because mediation is, as I said, founded in reason, in dialogue, in mutual understanding and mutual give and take, in which we understand the perspectives of each other. In that sense, it leads to the creation of a more stable and cohesive society.
With its proactive approach and impressive track record, Samadhan will continue to change the legal system in India for the better, one mediation at a time.
Ladies and gentlemen, I think the judges, including former Chief Justices and acting Chief Justices, for instance, we have Dr. M.K. Sharma, Justice A.P. Shah, Justice Geeta Mittal, Justice Mukul Mudgal, Justice Sastani. I think they have done a lot of work. They have created this institution which has helped reduce acrimony in the society, and they deserve a rich round of applause. Now let me tell you how the concept of this conference evolved. Last year, when we held our in-house mediation training program in Manesar, both the bar and the bench participated enthusiastically. We had the problem of plenty. In the sense, much against our grain, we had to decline requests of a number of lawyers who wanted to participate in the training. We had also invited a number of honorable judges from the Supreme Court who were members of the MCPC to chair the various sessions. We were informed by a few of their lordships from outside Delhi that there was a wide disparity in the approach of the bar and the bench in India towards mediation. So we realized that while some courts in India value mediation as an alternative dispute resolution mechanism, others barely treat it so. Since mediation in Delhi is successful and popular, we at Samadhan felt we had a story to share so that the experiment in Delhi could be replicated all over India. Therefore, Samadhan wrote letters to the Honorable Chief Justice of India and the Chairman MCPC, asking them to participate in this initiative. Soon thereafter, I got a WhatsApp message from Justice Kaul stating that if you are doing a national level program, you will have to involve the MCPC as an umbrella body. Any court-going lawyer will tell you that any observation by a superior court is an opportunity to improvise and adapt your case. So after some deliberation, I replied, "Sir, conference propelled by a double engine is always better." Promptly came the response, "Fine, now think big. We will support you in all respects, including getting speakers from abroad." A few days after the WhatsApp exchange, the Honorable Chief Justice of India happened to come to this very auditorium for another conference. He told me to go ahead with the conference and that he would also speak to the Chief Justice of Singapore to attend a seminar. Chief Justice Singapore is participating in this conference only due to the efforts put in by the Chief Justice of India and Justice Kaul. They also asked us to take the advice of a mediation expert, namely Justice Narasimha. This is how the organization committee was formed and the program was finalized. The book, Mediation and Its Promise, was conceived when Justice Narasimha suggested that we adopt a format of a theme article written by an academic and other articles written by distinguished experts who have engaged deeply in the subject in different ways. But this decision was a hesitant one because we had less than a month in which to contact our authors, to put in independent illustrations connected with the articles, and finally printing. 3 weeks back, we had 2 articles. But 2 weeks back, we had 19 articles. Miraculously, 1 week back, we sent this labor of love into print. I call it labor of love because every author we approached, ranging from the most distinguished experts from India and abroad, former and sitting judges of the Supreme Court as well as the Delhi High Court, rose to the occasion and touched our hearts by putting aside everything to beat the deadlines and exhibit their deep personal commitment to honor mediation and make this book possible. Our deep gratitude to all the authors, to our talented designer, Mr. Vinay Jain, our young team of illustrators from Spinetail, who took on the challenge of making original and evocative illustrations for the book within such a tight deadline. I wish to thank our publication committee and our editors, Ms. Sadhna Ramachandran and Mr. Sudhanshu Batra, for whom to bring out this book was nothing less than a trial by fire. So thank you, the Honorable Chief Justice of India, Justice Kaul, and Justice Narasimha for hand-holding us and in planning this event. I also thank Ms. Santosh Naiman, Member Secretary NALSA, and Ms. Mezi Volu, Member Secretary MCPC. Mediation is like returning to our roots. India has a long tradition of resolving disputes through elders in the family. In mediation conducted by Samadhan, parties are encouraged to find their own solutions to the disputes. In this process, they are facilitated by a trained mediator who guides them and offers advice when asked for. Consequently, mediation is an amicable way of resolving conflicts that is consistent with our culture and values. While mediation is largely an out-of-court process, it's a misconception to suggest that mediation hurts the rule of law by taking the law out of the hands of the court. According to Justice Sundaresh Menon, Chief Justice Singapore and High Court, by enhancing the prospect of achieving final and acceptable outcomes when disputes arise, and by providing an often more timely and cost-efficient alternative to other methods of dispute resolution, mediation offers a real and vital option in helping to address legal needs that might otherwise go unmet." Unquote. Consequently, access to justice entails a fair resolution of the dispute, and this need not come only through the adjudicative process. Mediation has gone through various stages in India. At first, mediation was resorted to only due to litigation fatigue. Then came a stage when it was deployed in combination with other adjudicatory methods like court litigation and arbitration. But now one is seeing mediation emerge as a standalone dispute resolution mechanism, especially where parties want to preserve their relationship, be it personal, social, or commercial. it is being seen as the most appropriate dispute resolution mechanism in various genres of dispute like family, matrimony, employer-employee, and as a tool to promote harmony and reduce acrimony in society. The theme of this conference has been coined with a lot of deliberation and has been picked up from the topic of tomorrow's plenary session, Mediation at the Dawn of Golden Age, for which Justice Sundaresh Menon, the Chief Justice of Singapore, is joining us. The other areas where we have experts to share their views are developing an institutional culture for effective mediation in courts, building trust in the mindset of the end user of mediation, and preparing for a mediation law in India. I sincerely hope that our discussions will be useful to you and you will be able to apply the same to settle disputes and bring tranquility in the society. I thank all the panelists who have agreed to spare their valuable time to participate in the national conference. I also thank my committee members, comprising Mr. Justice Sanjeev Sachdeva, Mr. Yashwant Verma, Mr. Naveen Chawla, Mr. Purushender Kumar Kaurav, Mr. Sudhir Kumar Jain, Mr. Vikas Mahajan, Mr. Saurabh Banerjee, Mr. Chetan Sharma, Mr. Mohit Mathur, Mr. Jatan Singh, Mr. J.P. Singh, Mr. Rajiv Virmani, Mr. Sudhanshu Batra, Ms. Sadhna Ramachandran, and Ms. Veena Rali, the organizing secretary. I thank all of you who are present today. I appreciate your commitment. You have just demonstrated this by sitting on the steps. I hope you enjoy the brainstorming sessions that are scheduled for tomorrow. But before that, please enjoy today's cultural evening by none other than the famous pianist, Mr. Brian Silas, and his team, as well as the dinner. Thank you.
Thank you. Thank you very much, sir. With this, ladies and gentlemen, we conclude the inaugural session of the National Conference on Mediation, but the evening is not yet over. Right now, let's express our gratitude to Honorable Chief Justice of India and other dignitaries. Put your hands together for a huge round of applause. We are thankful to Honorable Chief Justice of India and all the dignitaries. और जैसा कि आपने सुना और जैसा कि आप जानते हैं, इस इनॉग्रल सेशन के बाद एक बहुत ही मेलोडियस परफॉर्मेंस है ब्रायन साइलस की, ए वेरी रनाउंड, वर्ल्ड रनाउंड पियानिस्ट, और उसके बाद हम डिनर के लिए प्रस्थान करेंगे. सिर्फ मे बी 8 to 10 minutes वी विल नीड टू सेटल द स्टेज फॉर द परफॉर्मेंस. आप सभी से रिक्वेस्ट है, प्लीज़ रिमेन सीटेड, और अगली परफॉर्मेंस में भी आपके प्रेजेंस के लिए हम आपसे प्रार्थना करेंगे. थैंक यू वेरी मच. We welcome Honorable Chief Justice of India and other dignitaries in the auditorium. दिव्य सज्जनों, आज की भागदौड़ भरी जिंदगी में हम सभी ढूंढते हैं, तलाश में रहते हैं, कुछ पल ऐसे सुकून के मिल जाएं, ऐसे पल जहां हमें खुशी का एहसास हो सके, जहां हम खुद अपने साथ या अपनों के साथ कुछ समय बिता सकें। ये सब कुछ मिलता है उस सोलफुल म्यूजिक के माध्यम से, उसके जरिए भी और उस मेलोडी में भी जो ब्रायन साइलस की पियानो से निकलती है और हम सबको भीतर तक सराबोर कर देती है। आपको ये बात जानकर हैरानी होगी कि ब्रायन साइलस ने संगीत की कोई भी फॉर्मल ट्रेनिंग नहीं ली, लेकिन आज अपने पैशन से, अपने लव फॉर म्यूजिक से, मेलोडी से दुनिया भर में उनका बहुत बड़ा नाम है और दुनिया भर में उन्होंने परफॉर्मेंसेस भी अपनी दी हैं। He loves to play old Indian film songs which have soulful music. He evokes the nostalgia of great music directors like Khayyam Sahab, O.P. Nayyar Sahab, S.D. Burman Sahab, Lakshmikant Pyarelal ji, Ravi, and of course, Madan Mohan. इन सब के गीतों की मेलोडी को आप एंजॉय करेंगे पियानो के जरिए ब्रायन साइलस की परफॉर्मेंस में। बट बिफोर दैट आई विल रिक्वेस्ट ऑल ऑफ यू टू प्लीज टेक योर सीट्स and maintain silence so that we can start the performance. Brian Silas, for fervor and reverence for piano is deeply religious. When he plays, he is one with his maker, the God. So ladies and gentlemen, let's welcome with a huge round of applause, the one and only one, the Brian Silas, the great pianist, the legendary pianist on the stage, who is going to perform for us today is this evening. Please welcome. और मैं I will request Ms. Mezibolu T. Theri, the Member Secretary MCPC, to welcome Mr. Brian Silas and present a small plant to the legendary pianist on the stage on behalf of the organizing committee. We are grateful to Mr. Brian Silas. He has come here to perform with us. Sir, that side, please, in the front of the stage. And of course, we will participate by putting our hands together for a huge round of applause, ladies and gentlemen. The Brian Silas. Thank you very much. स्वागत बहुत बहुत आपका आज के इस इवनिंग में। और ये भी आपको बता दें कि आज आपके साथ जो दो कलाकार इस परफॉर्मेंस में साथ में होंगे मंच पर, उसमें गिटार पर जयदीप लखटकिया जी एंड तबले पर तुलसी माधव जी, उनका भी बहुत बहुत स्वागत, अभिनंदन है। सो लेडीज एंड जेंटलमैन, लेट्स बी पार्ट ऑफ द रोमांस बिटवीन ब्रायन साइलस एंड पियानो एंड फील द लव, द पैशन थ्रू द म्यूजिक ऑफ Brian Silas.
ये भी दुआ ही है। up and treble down. Control to down. वो ट्रेवल कम कर दे तो बेस बढ़ा दे. Rata Lambi. It's a new song. That was all I remember. दो गीत मिला करके I'm going to play a medley for you. I hope you like it. favorite? One last song.
What an evening, what a performance. रेशम के मुलायम धागों सा एहसास उस म्यूजिक का जो ब्रायन साइलस सर का है. Thank you very much, sir. We are grateful to you for this wonderful performance. Thank you.
यहाँ पर खड़े होकर I am feeling so lucky to be a part of such a prestigious August gathering. Thank you so much for inviting me.
Thank you, sir. Thank you. We are grateful to you. And we are thankful to Jaideep Lakhiya ji on guitar. Thank you, Jaideep ji. Tulsi Madhav ji on tabla. आप सभी का बहुत बहुत आभार. Thank you very much. And thank you very much to all of you, ladies and gentlemen. ये सचमुच ये इनॉग्रेशन सेशन आज का बहुत खास रहा, बहुत खूबसूरत रहा, बहुत सारे एहसास के साथ हम यहाँ से जा रहे हैं. We are grateful to Honorable Judge Supreme Court Executive Chairman, NALSA Chairman, MCPC, Justice Sanjay Kishan Kaul जी, आदरणीय Honorable Mr. Justice राजेश जिंदल जी और सभी डिग्निटरीज का, सभी ऑनरेबल जजेस का, सभी जो लोग यहाँ पे पधारे, आप सभी को मैं इनवाइट करता हूँ डिनर के लिए, because this is time for the dinner. और ये first of all, the honorable judges will be escorted to the dining area, and all of you will exit from the back side. On the same floor, and the dining hall is there. So you all are invited for the dinner. कल सुबह 10 बजे का समय है. We will start with our first session of this national conference. You all are requested to be the part of this event and bless us as usual. Thank you very much and good night, ladies and gentlemen.